everybody, but we will try to do our best to address general questions. We're going to be monitoring them, and Deb, who popped in to help us with the technological aspects of this webinar, is going to be monitoring them as well. If you don't get your questions answered, please feel free to email us at snlgadmin@specialneeds-law.com, and we will try to answer your questions after the webinar. But also, we wanted to let you know that this recorded webinar and presentation slides will be available at our company website at www.specialneeds-law.com shortly. We're hoping to get them up in a couple of days. Again, I am Annette Hines, and I am the owner here at Special Needs Law Group, and this is my partner and husband, Mark Worthington, and he is the genius behind the slides and the presentation today. If anybody would like to be contacted about reviewing, updating, or creating any estate plan documents that have to do with the content today, you can call us at 508-861-3453 or email again at snlgadmin@specialneeds-law.com. Please remember,
if they're Massachusetts residents.
If you're Massachusetts residents. If not, you can get in touch with us and we'll be happy to connect you with a professional in your state that's part of our network that we know and trust. Please remember to mute your camera, your microphone, and your telephone so that we don't hear buzzing, jingling, and all kinds of noises in the background. I wanted to just thank you all for coming and stopping in today. We we didn't put the materials together at the last minute, but we threw this webinar up at the last minute. We also I did a podcast on this as well, so that's available on Apple and Stitcher and every place that you can find your podcast materials. So that went out yesterday.
Well, the podcast is called Parenting Impossible.
Parenting Impossible, the Special Needs Survival Podcast. So that's another place to get the content. And we are trying to get the word out about the changes relating to special needs trusts and the Secure Act. There's also a blog piece that went out to our list, and it's on our website as well at specialneeds-law.com. So without further ado, Mark Worthington.
All right, thank you. I will say today's webinar is what I would characterize as, it's for lay people. It's not to blow everybody away with a bunch of technical gobbledygook. If you are an attorney and are interested in a higher level of technical information, and you are a member of the National Academy of Elder Law Attorneys, we have a webinar tomorrow at 2 p.m. Eastern Time for an hour and a half, and you can sign up for that if you're a member of NALA. And I would characterize that as moderate technical level. The high level technical stuff will be forthcoming, and I may put that out on the Lissy Weinberg Information Network. Anyway, so let's get going. So this is about the Secure Act and Special Needs Trust. This is the usual stuff we always have to say, which is that an attorney-client relationship is informed by you listening to me or doing this and blah, blah, blah. Okay, so good. And just a little bit about Annette and me. You can read that on your own. I don't want to take time for that now, but it helps, I think, people to are familiar with us to know a little bit about who we are, that you're not hearing this from just some nobody fly-by-night person who just happened to take an interest in the Secure Act. So, background. There's three things to know before we can really talk about the Secure Act and what it did. Now, the Secure Act was signed into law on December 20. And it makes some very radical changes to retirement plans. So we're not going to talk about all the changes, but we're going to particularly talk about the changes as they affect special needs trusts. The background that we need to talk about is three things: income taxation of retirement plans and the stretch, and then retirement plans and their interaction with trusts, and then finally trust income taxation. So if that sounds overwhelming, take a breath, calm down, we'll be okay. So retirement plans and the stretch. So IRAs and qualified retirement plans, so we're talking about things like 401ks and 403bs, there's a few others. They're important because they're a large and even a dominant part of people's net worth these days. And traditional retirement plans, that means non-Roth retirement plans, are almost always 100% taxable income. And that'll be our assumption for the rest of this presentation. The tax occurs when money is withdrawn from the plan. Now, Roth retirement plans, generally they have a 100% basis and there's no income tax when money is withdrawn. Traditional retirement plans, in case you've heard of this thing called a step up in basis or a basis adjustment at death or something like that, that's true about things like real estate and conventional stocks and bonds, or not bond, well, conventional stocks, things like that, where if you bought Apple stock at $100 years ago and now it's worth $250 a share and you die with it, your beneficiaries when you die get a $250 a share basis and they can sell it with no capital gain tax. It's a permanent forgiveness of the capital gain tax. But a lot of stuff doesn't get that step up in basis, and the biggest thing that doesn't get that step up in basis are these traditional retirement plans. There's still 100% taxable income waiting to happen. Now, the next thing that you need to know, which should not surprise you, is that Congress wants their tax. The government is rather hungry for this. A traditional retirement plan owner has to begin taking required minimum distributions during their life if they live long enough. That age used to be 70 and a half, and the Secure Act changed it to 72. Now, the required minimum distributions for Roth plans only starts when the retirement owner dies, the plan owner dies. But the Congress isn't as concerned with that because the tax was already paid on the money before it went into the Roth plan. So these required minimum distributions during the life of the traditional plan owner are based on the owner's life expectancy, but at death things change for both traditional and Roth plans. Prior to the Secure Act, what happened was if the plan had a designated beneficiary, which we'll talk about what that means, the required minimum distributions were based on the life expectancy of the designated beneficiary. Well, that could be decades. And that came to be known informally as the stretch. Now, if there was no designated beneficiary, the plan had to be emptied out within 5 years of death, or in some cases over the remaining life expectancy of the plan owner, but that usually wasn't very long. So as an example, if an 80-year-old died with a $1 million IRA and left it to their 50-year-old child, well, the child has a life expectancy of around 35 years. So the year following death, the child had to withdraw just 1/35 of the plan balance. That's just about $28,000. And if the plan had a 5% return, which is not that great, the plan actually increased in value. And then the next year, the child had to withdraw 1/34 of the plan balance and so forth. And the great thing about this income tax deferral, the stretch, is that it's not merely postponing paying of income tax. If you work out the algebra, it's really more real net present value dollars for the beneficiary. It's really more money, not just deferral of income tax. Now, so that's one value of the stretch. Now let's take a look at retirement plans and trusts. So a designated beneficiary, so to get this stretch, you have to have a, quote, designated beneficiary. Well, that's not just a beneficiary you designate. It has to be a, quote, designated beneficiary. It has to be an individual or a group or class of individuals that is structured in such a way that we can determine, well, who's the oldest one? In other words, the one with the shortest life expectancy. If we can figure that out at the moment that the plan owner dies, then we have a designated beneficiary. An example would be my descendants who are living at my death. Well, guess what isn't a designated beneficiary? Because they're not individuals. Charities, estates, and trusts. But two kinds of trusts are still allowed to be designated beneficiaries anyway, because we can look through them and we can ascertain for that kind of a trust who the oldest or who the person is with the shortest life expectancy. Now, if you're not used to dealing with the world of trusts, It may seem like, well, why is that a big deal? I mean, you look through, you see who the beneficiaries are. But in the world of trust, when we talk about beneficiaries, we're talking about not just the people who will be taking immediately. We're talking about every person who could possibly take under every contingency, no matter who dies, in what order, and no matter how long the trust goes on. That's a lot of people, and it can be people who are unknown, unascertained, and so forth. So we have to be able to figure out how do we know who the oldest person can be. And there's only two kinds that can qualify: conduit trusts and accumulation trusts. Well, a conduit trust is just a trust that requires all withdrawals from a retirement plan, whether it's required minimum distributions or greater, to be immediately paid out to the trust beneficiary. See, that's just mimicking the same thing that would happen if you left the IRA directly to the individual. They can take out the minimum distributions, and when they die, they can have a successor beneficiary. And all we do in that case is look at the life expectancy of that first tiered beneficiary. Same thing with a conduit trust. Problem is, it's not a really great result where the beneficiary isn't appropriate to manage their own funds. Maybe they have gambling problems. Maybe they just aren't that savvy, that, maybe their judgment just isn't that great. It's not good for asset protection planning either, or if you are concerned, just want to make sure that the assets are protected if your child, were ever to get a divorce or something like that. But the real disaster is a beneficiary with special needs. We don't want the trust to be required to make distributions to that beneficiary if that beneficiary is on public benefits programs that are asset or income sensitive. So we don't use conduit trust provisions in a special needs trust. What we do use is accumulation trust provisions within a special needs trust. That permits the trustee to have the same discretion to distribute or not distribute retirement plan withdrawals as with any other asset of the trust. At the same time, they can use the beneficiary's life expectancy to determine the required minimum distributions, even though we have to look through the trust to determine, well, who might possibly ever take after that special needs beneficiary dies. I mean, we don't know who's going to be living at that time. So, even if we say, oh, it's our other children or something like that, we can't guarantee that they're going to be around. So it could be Uncle Methuselah who ends up taking. It could be a charity. So, and all of those things under the old rules would disqualify the accumulation trust from being a designated beneficiary. So a retirement plan accumulation trust fixes that with a lot of restrictions drafted into that trust. Very complex to draft, but really not any more difficult to administer than a conduit trust. It can't have any charitable remainderment, that is, charities that take after the death of the special needs beneficiary, no matter how remote. And no one older than a particular person can ever be allowed to take, no matter what the circumstances. So we cut out Uncle Methuselah. Now this is perfectly suited for special needs trusts. Finally, we need to talk about trust income taxation, a particularly icky subject. After the plan owner's death, trust is irrevocable. It becomes its own taxpayer with its own taxpayer identification number. Now, income taxes. Single individuals hit the top federal income tax rate of 37% at over $500,000 of taxable annual income. Married filing joints even higher, $622,000 of annual taxable income. And don't forget, many states like Massachusetts, where we are, has another 5% or so tax to add on top of that. What about trusts, where they hit the top federal rate of 37%? Wow, just $12,950. Now that's in there since the late 1980s, early 1990s. And the reason is because Congress was worried that people would set up trusts to get more runs up the, income tax brackets and so forth like that, and steal money from the U.S. Treasury. But it's important to understand how this works. You see, if the trust makes distributions, it carries out taxable income away from the trust and out to the beneficiaries where it's taxed at the beneficiary's tax rate. If I have $20,000 of taxable income in the trust, but I distribute $10,000 to the beneficiary, $10,000 gets carried out to the beneficiary's income tax. Trust only keeps $10,000. That's taxed at various rates below 37%. And so we spread the income tax out between the trust and the beneficiary. So for retirement plan accumulation trust, which means most special needs trusts, the stretch is extremely important because we need it in order to manage competing factors, the needs of the beneficiary, public benefits, impact of distributions, and income taxation. The longer we can stretch out these retirement plans coming into the trust, the greater the flexibility the trustee has to manage these distributions. So what does the Secure Act do? The Secure Act, we've been watching some form of this for over 2 years now, basically about 2.5 years. And we knew something was coming at some point, but basically what we knew was coming is that it was going to eliminate the stretch. The surviving spouse still has a lot of options. The surviving spouse can still roll over the plans, but for other beneficiaries, we now have 3 things that could happen. The default is that all money has to come out of the plan within 5 years of the death of the plan owner. It doesn't have to come out ratably, 1/5 each year or anything like that. It just all has to come out within 5 years of the death. Now, actually, the 5-year rule is a 6-year rule because if you die, say, in the middle of 2020, the 5-year rule means that you can take out some in 2020, 2021, 2022, 2023, 2024, 2025. Right, so you really have 6 years. It has to come out by December 31st, 2025. If you have a designated beneficiary, however, you've got 10 years to do that, meaning 11 calendar years, and that replaces the stretch. There is no more stretch except for eligible designated beneficiaries. Now, eligible designated beneficiaries we didn't see until a version of the Secure Act that came through the House of Representatives in May of 2019 by a relatively bipartisan vote of 417-3. And that exception applies to eligible designated beneficiaries. They can still get the stretch. Who are they? 5 different kinds. The surviving spouse, which may or may not be important. Most of the time, it's not that important because retirement plans just get left to the surviving spouse outright. Children under the age of majority, which is generally 18. Disabled, chronically ill, and individuals not more than 10 years younger than the plan owner. What we're going to focus on is the disabled and chronically ill. And the initial reaction among special needs attorneys, they looked at this and they said, oh, we're good. This is going to work. This is going to be fine. But a detailed analysis was performed, and that analysis showed that special needs trusts would not qualify for the stretch. Based on that analysis, the Tax Steering Committee of the National Academy of Elder Law Attorneys submitted an issues brief to the Congressional Joint Committee on Taxation in August of 2019, pointing out not only that this was a problem, but exactly why it was a problem.
A happy camper.
Okay, and then
My microphone?
oh, yes.
Okay.
Hi, we're hearing some interference here.
I'm sure it's me.
Oh, no, mute.
Okay, I'm trying to find how to...
Hi, can we stop this, please? Okay, thank you.
Okay, so
Yes.
special needs trusts,
Yeah.
not included.
Yeah, so special needs trust would have been stuck with the 5-year rule as the Secure Act stood when it was passed by the House of Representatives in May of 2019.
So the Tax Steering Committee took this up,
Yes.
headed by you.
Well, I'm not the chair of the Tax Steering Committee.
It's all good? Okay, thanks, Deb. But you
What do you want to say?
I'm very proud of Mark because he basically did all of the research and wrote the brief.
Yes, so I will pat myself on the head. I'm the pinhead that did the detailed analysis, and I'm the pinhead that wrote the issues brief. So yay me.
Yeah.
So this is my 15 minutes of fame, if any of you remember Andy Warhol. Okay,
So then.
Yep. Oh, now you've spoiled my surprise. Go ahead.
No, go ahead.
We're done? Okay. So we waited, and we didn't hear anything, and we didn't hear anything, we didn't hear anything, and then we heard that the can was getting kicked down the road to March of 2020. And suddenly, in late December, Secure Act reappeared and was, like within days, signed into law. And the great thing is that the Joint Committee on Taxation did a remarkable job taking the technical details that we wrote up in our issues brief and crafted legislation that addressed the problem. So we now have, we saved the stretch for special needs trusts, at least that they're drafted in certain ways. So what a special needs trust now has to have, now we're always talking about third-party special needs trusts in this presentation, not first-party. First-party meaning something like a D4A or a D4C pool trust funded with the beneficiary's own assets. We're talking about typically inherited assets that were never the assets of the disabled person. So the Secure Act provides that if the only initial beneficiaries of the special needs trust on the death of the plan owner are persons who are disabled or chronically ill, then we only have to consider their life expectancies, and we can use their life expectancies in determining the required minimum distributions. We do not have to consider the remainderment as we would for any other retirement plan accumulation trust. And by the way, the Secure Act basically killed retirement plan accumulation trusts for any kind of trust other than these special needs trusts that I'm describing here. So what does this mean for you? So backing up, remember, one of the things that it does is that lifetime required minimum distributions for traditional plans begins at age 72, up from 70 and a half. There's no more age limit for contributions to IRAs. But what we really want to focus on here is the required minimum distribution rules taking effect at death. So those rules under the Secure Act take effect for deaths for people dying after 2019, and that's not just for plan owners, it's also for beneficiaries who die after 2019 of plan owners who died before 2020. So as an example, if a plan owner died in 2015, left their IRA to child who has a 35-year life expectancy, then the final year of required minimum distributions for that child would be 2050, 35 years later. Doesn't mean the child couldn't take out the funds faster, but that's the time. By then, they all have to be out of the plan. So the Secure Act 10-year rule the 10-year rule that substitutes for the lifetime the life expectancy rule has no effect on the child respecting this inherited IRA. But then suppose the child dies in 2030, and that child leaves the remainder of the inherited IRA to grandchild, the child of the child. Well, the grandchild is now subject to the 10-year rule. So everything has to come out of the plan by 2040. Prior to the Secure Act, the grandchild can continue to use the original RMDs and take out as slowly as up to the year 2050. So the big message here really is, and I'm sorry if this sounds self-serving, but all estate plans need revisiting. And almost all trusts are going to need updates if you have retirement plans. In my rather lengthy career, about a quarter of a century, there have really only been 2 times when law changes have really driven a need to revisit, redraft estate plans. And both times have been because of changes in the rules affecting leaving retirement plans to trust. One was in 2002 when we got the current regulations, and now the Secure Act. So it's particularly critical that special needs trusts get updated. So let's go through this. What stays the same? If you've got a special needs trust with retirement plan accumulation provisions, which if you have a special needs trust and you have retirement plans, I sure hope you have retirement plan accumulation provisions in there. What stays the same? Well, the retirement plans and the accumulations of those retirement plans have to be kept segregated from other trust assets. So there has to be provisions in there that require that. What restrictions in the pre-2020 retirement plan accumulation trust are loosened or eliminated for these special needs trusts? Well, charities are now permissible remaindermen. The remaindermen don't affect the life expectancy distribution, or the RMDs over the life expectancy of the special needs beneficiaries. We don't look at the remaindermen under the new rules, so that's really nice. And there's no age restrictions on the individual or classes of individual remaindermen. So it can go to Uncle Methuselah at the death of the special needs child if Uncle Methuselah manages to survive that long. What new or tightened restrictions are there? Well, all beneficiaries of the special needs trust upon the death of the plan owner must be disabled or chronically ill. That is, all of the current beneficiaries, not the remaindermen. So here's some examples of things that are not uncommon to find in special needs trusts that we've now got to get rid of. You can't have typical children or other non-disabled, non-chronically ill people permitted as discretionary beneficiaries during the lifetime of the individual who is disabled. You can't have a pot trust. This is really the same thing. You can't have a pot trust for young, typical, and disabled children together, sometimes called a children's common trust, something like that. No provisions permitting trustee discretion to benefit guardians or caregivers, other than, as compensation for services, but not just to be nice to them. No discretion to benefit the disabled or chronically ill individual's children or descendants unless they're also disabled or chronically ill and living at the death of the plan owner. And in essence, what this means is the special needs trust really, it harks back to the sole benefit rule that we had and still kind of have for D4A trusts. Before the new Social Security POMs were released April 30th, 2018. I know I'm getting a little technical there, but some of you may know what I'm talking about. The trust really ought to have some sort of a notwithstanding clause as kind of a catch-all that says, notwithstanding anything else you may read in this trust, retirement plan assets can't be spent to benefit anybody except these individuals or this individual who is the primary beneficiary or beneficiaries of the special needs trust. No other persons can benefit from the trust until the last of the initial disabled or chronically ill beneficiaries dies. As soon as a new beneficiary is introduced, even if they are also a disabled or chronically ill person, the 10-year rule kicks in. You still have to have restrictions on trust amendments, decanting, powers of appointment, and so forth, but they're even tighter now. Not merely age restrictions, but no possibility of any other individual other than those initial disabled or chronically ill beneficiaries can benefit during their lifetimes. Funding. So I think that the best estate planning approach is generally, not always, but generally to name the revocable trust as the central point where all assets come and then are divided out amongst all beneficiaries. And we got some new rules with the Secure Act that allows us to do this in a very nice way so that we can look at the life expectancy of the special needs trust beneficiaries separately for determining required minimum distributions, even when the split is at the revocable trust level. So at the revocable trust level, you might want to consider a clause that allocates Roth plans to the special needs trust. And you may want to have a provision that figures, well, let's see, like, do we want to allocate retirement plans to the traditional or to the rather to the typical kids who may be in lower tax brackets than the special needs trust, or do we want to allocate it to the special needs trust where we can get the stretch instead of being stuck with the 10-year rule that we are with the typicals? If enough money is at stake, this may require a mathematical analysis, and there are tools coming online even as we speak to enable professionals to do that. You should consider maybe converting some of your traditional plans or a portion of them to Roth plans. That can help the planning for both the typicals and the special needs kids. Let's see, what else have we got here? Oh, and then on the typicals, because we don't want to forget them either, it used to be that I would say that a conduit trust was a clear winner in terms of planning over an outright distribution of retirement plans, because at least, over their life expectancies, you got some asset protection, you got other estate planning benefits like, some divorce protection and so forth. But it's no longer a clear winner because you have 10 years and that's it. You don't have a lifetime. As far as choosing for typicals outright or conduit versus an accumulation trust, we're stuck with a 10-year payout no matter what. And the question is, it's a balancing question. How important is the asset protection, divorce protection, et cetera, that you get from an accumulation trust for each particular beneficiary? Or is each particular beneficiary able or unable to handle their own investments and spend wisely versus the anticipated marginal income tax rates for each beneficiary versus the trust income tax rates? So these are going to be very individual questions to decide with your estate planner. And I think I'm done.
Let's move to questions.
Okay.
And I have a few.
Uh-oh.
So let's
I have to go.
Stop sharing. He's always scared of my questions.
Are we still broadcasting?
We are. Where is the... No. Go back to high five. Okay. Does anybody have any questions?
I thought you had collected some.
I have some questions.
Uh-oh.
Okay. All right. So, Mark, one of the things that occurred to me as I was listening to you talk was, even as a planner, this all sounds very complicated.
Mm-hmm.
And I've always thought that adding special needs trusts into the mix, the special tax rules, it starts ratcheting up the complexity in a plan. And in fact, we always talk to our clients about added complexity as it is. How does this add to the difficulty that people have, when they are trying to pull together a team of their experts in, helping advise them, and B, how do they select that team to carry them forward? As they're thinking about who their trustees are going to be, who their guardians are going to be, who their conservators are going to be. These people are going to need to be able to understand on some basis how to do these required minimum distributions, how not to mess up these rules. Yes, they should be able to rely on the professionals in their life to advise them, but when you call up your retirement plan provider, your investment provider, your tax planner, and they're having a hard time explaining all of these things to you, maybe they don't have attorneys who are as awesome as we are. Let's chat for a second about how clients or how, people in general are supposed to move forward with, they need a plan that has this complexity in it to address their needs, but how are they supposed to begin to pull together this team of advisors for themselves, and B, select who they can put in place to carry on for them afterwards?
Well, we probably need about 3 hours to answer that. A number of things occur to me, so let me just kind of blurt them out. First of all, I would say that what the Secure Act does is it does simplify some things in some ways. The drafting and the planning, I would say, probably is even in some ways more complex than it was before. But that's the drafting and planning side. I think in terms of administration, it's no more complicated, and in fact, in some ways, has made the administration of a trust after somebody dies easier. That's number one. Also, don't forget, when you're in the planning mode, sometimes, not always, but from time to time, we run into situations where we don't have all these complicated provisions. A couple of examples: if the retirement plan is relatively small,
right?
Say the retirement plan is $50,000, and it's going to come out over 5 or 10 years. Well, that's manageable in a trust without special provisions.
Right.
Or let's say that the beneficiary, pardon, I'm recovering from a cold, everyone. Say that the beneficiary's real benefit that they really, really care about, that they really depend upon, is Section 8 housing, and the rest of the stuff out there isn't that important. Well, a lump sum, and they can manage funds, and they have good judgment and so forth. They could receive an outright distribution of a retirement plan, and that's okay. That really won't affect their Section 8 housing except in a very, very, very marginal way. Mm-hmm. So that would be fine. So sometimes we don't really need the special needs trust for somebody, even though it might initially look like it. Mm-hmm. The second thing is, so I've talked about planning. Now, in terms of administration, any trust, there's more to administering it than kind of meets the eye. And even though, again, it may sound self-serving, professionals, attorneys that really understand trust law are kind of important to the mix. Whether they are hired by a family member trustee, this is after you die usually, okay? Or they are hired, or somebody is hired as a professional trustee. Understanding how a trust is to be respected as a separate entity, the accounting, the taxes, and so forth. Mm-hmm. Special needs trusts are yet a whole nother world of complexity because of the public benefits rules.
Right.
And not only the public benefits rules, but the non-legal thinking that comes into play of how can I use this trust to make a better life for this person. Mm-hmm. That requires a level of creativity I don't have, and that's why you're around. The third thing is, so I would say that the tax issues surrounding the minimum distribution rules and trusts and so forth like that, yeah, it's another layer, but it's necessary. You got to deal with it. There's no getting around it.
Right.
And if you've got a substantial retirement plan, the cost of not addressing it is horrific taxes that are going to really punish your beneficiary.
Yes.
You don't want to do that. And
as you said in the beginning, most people, that is one of the two most substantial assets that they have.
That's
to
right.
Leave their beneficiaries.
So in terms of the team and so forth, you either need a family member, a friend, whatever, a non-professional who really gets it and understands that they need to take this as a serious separate entity and hires good advisors. Mm-hmm. You need a really good special needs attorney. You need the accounting and the financial professionals. Or something that we suggest a lot of times is, don't do this to your other kids. Have the trust pay the money. This is after you die. Pays for a professional trustee. But your typical kids or other family members or friends or whoever, other people who care about your special needs child. Of course, nobody will ever care as much as you do, but other people who care can be in a supervisory role. Sometimes the role is called a trust protector, but there's other names for it too.
Yeah.
They can serve as an oversight role. They can get accounts. They can sit in judgment basically over the professional trustee. They can have the power to remove or replace that professional trustee with another for any reason, but they don't have the liability and they don't have the month-to-month, day-to-day work that needs to be done if they were serving as a trustee. So I don't know if that answers your question.
That's good. Well, let's go to our questions. So do you think it's okay to name a revocable living trust as the beneficiary and allow the trustee to decide how to split it post-death of the employee or the IRA owner?
I don't know that works. I mean, what does work is allocation clauses that say, here's how to allocate between the special needs trust and the typicals. Simply giving the trustee a power, I
can't imagine how can that work? You have to have.
I think it needs to be able to. I think it needs to be fixed at death. I would be very concerned about that, but I have to confess that I wouldn't want to stake my life on the answer.
That would be worth thinking about, though. I
wouldn't want to stake my life on the answer without a lot of research. I would say this. I would say I think that the answer probably, and when I say probably, like I'm probably 80 or 90% sure that the answer is that that's not a good idea and that it needs to be fixed by formula in some way. It can be by formula. It doesn't have to be, like exact, like all this goes here. It can be, some fractional amount sufficient to, fully fund the share, et cetera, like that.
I mean, how do you get to the grantor's intent if everything's up to the trustee?
No, that I'm not worried about. I'm worried about the whether or not you have an allocation clause that, number one, is respected for the separate accounts rule. I'm getting technical here, guys. The separate accounts rule says that this is a new thing under the Secure Act. The separate accounts rule says that if the revocable trust splits between the typicals and the special needs trust, then if the special needs trust is the kind that qualifies, that you can, you don't have to consider you don't have to consider all of the beneficiaries as beneficiaries of the IRA for determining minimum distributions. You can consider the life expectancies of just the special needs trust beneficiaries separately. I'm concerned that if you did not have an absolute formula allocation in the revocable trust, that might not be, that Secure Act provision might not be respected. But I admit that I'm speaking offhand. What was the second thing that I was concerned about? The second thing I'm concerned about is the IRS erroneously regards pecuniary formulas allocating IRAs and so forth as accelerating income in respect of a decedent and therefore triggering income tax. And my concern is that a discretionary trustee allocation would do the same thing. Now, the IRS is wrong, and Natalie Choate explains that in her book. I forget the section of her book where she describes that, but she's brilliant on it, like most things. But in order to avoid that controversy, I always use a fractional formula clause in my allocation clauses for IRAs. And I don't think you can really achieve a fractional formula allocation with trustee discretion. I guess we should get to the next question. I probably not answered that very well, but I tried.
Definition of disabled is the same as SSA, as I understand it. I don't think so, right, Mark? What if the beneficiary gets a job and is no longer considered disabled? Now what?
Well, I've thought about that, and I don't know the answer. And I don't think that the Secure Act contemplated that. The Secure Act sort of kind of contemplated that in the fact that it cites to the definition of chronically ill under Section 7702 of the Internal Revenue Code. And it says, but you're going to substitute, there's a 90-day, the 7702 chronically ill talks about like 90 days. And the Secure Act says, well, substitute, no, chronically ill for like a really long time, which obviously isn't very well defined, but clearly it means at least 91 days, right? Nobody knows. And I've not seen any of the commentators in the 2 or so weeks since the Secure Act came out opine on this. I don't think anybody knows what happens if what's that Monty Python thing from, I'm getting better. So I don't know what happens. Also, the remark is definition of disabled is the same as SSA as I understand it. Well, that's interesting. No, it isn't.
Not.
They cited to the definition of disabled in under the annuity section 72. So 72M7, and the definition that it says, substantial gainful activity. The same stuff you see in the Social Security definition. But then you start digging through the regulations under Section 72 of the Internal Revenue Code, and you find something different. So under 42 U.S.C. 1382 CA3, where the statute talks about substantial gainful activity and so forth, and you dig, and you find that what they're talking about is you can't really do anything anywhere in the country that can earn you enough money to get by. Under 72 section Internal Revenue Code 72M7, it's different. Substantial gainful activity means you can't do the work you used to do. So I remember some of the old disability policies. I know somebody years ago who was a surgeon and developed all kinds of varicose vein problems, stuff like that, couldn't stand anymore during surgery, retrained as an anesthesiologist where he could sit down, and collected disability because he couldn't be a surgeon anymore under his policy, but was still earning plenty of money as an anesthesiologist. So that's what I read under 72M7. Now, how it's actually applied today, I don't know. I'm not a disability annuity type of attorney, but there is a difference in the definition, and it'll be interesting to see how that may play out later. But again, back to I think the larger question, what happens if the individual, quote, gets better? I don't know.
Well, Mark likes chalk and letters and numbers. I would like to get back to a little bit more practical question.
Okay.
Let's talk a little bit about if your head is swimming, a question that comes up a lot in our conference room before, and I'm sure will come up again, which is, I've talked to my financial advisor, maybe I should just not leave my retirement plans to my special needs kid. Shouldn't I just leave my retirement plans to everybody else? And then I don't have this problem. Why can't I just do that? Wouldn't that be a better solution?
You asking me?
Yeah.
Okay, so
let's just talk about that for a minute.
That used to be a relatively viable question or approach when we could have lifetime distributions to the typical kids, or to trust for the typical kids if they were structured either as conduit trusts or accumulation trusts. We can't anymore. Excuse me. So now, interestingly, the law in some respects is made, depending upon the circumstances, may make the special needs trust the preferred vehicle to cite as the inherited retirement plans.
Interesting.
So, number one, the best place for your Roth retirement plans to go is the special needs trust. Period. End of story. We get lifetime distributions, tax-free withdrawals. It's just awesome. Okay. So, but then the traditional retirement plans, it's going to vary depending upon the anticipated tax brackets of the typical kids versus the trust tax brackets, and how big are the distributions going to be, and can we use them effectively for the special needs child each year to draw down the taxable income left after distributions to below $12,950, and blah, blah, blah. It just gets very complicated. And, you know, if the plan is kind of small, maybe it doesn't matter that much, but, you know, you get these plans that are like millions of dollars, and it's like this becomes a very, very, very big tax deal. Whether it's better in any given situation to have the traditional retirement plans go to the typical kids or the special needs kid is really going to be a question of the numbers and to some extent client preferences,
Yeah.
Clients' feelings about issues like asset protection for the typicals, divorce protection for the typicals, things like that. Not a slam dunk. Roths are pretty much a slam dunk.
And, you know, what are the clients going to need through their retirement years too?
Well,
what makes sense, and where are they going to draw their money from?
Yeah.
Yeah. So it's so important for people to have a good team together of their tax advisor, not just somebody who prepares your tax return every year, but somebody who actually advises you about tax issues. Your attorney who's doing your planning, not just somebody who fills out some documents and, you know, and then you're done and puts them in a pretty little binder and that sits on your shelf, but somebody you actually meet with every so often. And, you know, your wealth manager, your financial advisor, and that's somebody who's doing an actual long-term plan for you, somebody who's looking at things for you every year or over time and doing, you know, some projections and that sort of thing. So at a minimum, I think most families really need that team.
Yeah. So, now, I mean, I think if I understand, I think I may know who S is here, and if S is who I think it is, he's has an LLM in tax, and he's out in California. So I've seen, for example, that Bob Keebler has 4 tools out, you know, like should you Roth or should you not Roth, stuff like that. I have not examined them yet, but they're Weinberg and Bob Keebler may be coming out with some useful tools. Like I say, I haven't looked at them yet, so I don't know. And it depends on your propensity for wanting to run through the numbers. You may want to. It may be that depending upon your personality and your propensity to crunch numbers, you may want to make sure that, or find, you know, a accountant or a financial advisor that would, you would rather have, you know, kind of get trained up with this kind of stuff. But like I say, for the typicals, and in a lot of cases, it's going to be case by case basis with a lot of the typicals, and it means that I'm in the process now. We do our own custom hot docs documents here, and so I'm busy now drafting various alternative allocation clauses in the revocable trust. But in every case, I want the Roths to go to the special needs trust, and or at least as much as I can stuff into it. If the Roths are big and they won't all fit there, I want as much as can go in there as possible. But then I have options about the rest of the estate plan as to how it gets allocated, depending upon what we conclude for each client.
Does anybody else have any questions before we wrap up? Also remember that a third-party SNIT comes with a $4,200 qualified disability trust exemption, so with that alone, you might be able to empty a qualified plan and pay no taxes. Steve Dale. Yes, if you qualify as a QDT. Not every third-party SNIT does, but some do, and you don't know that just from looking at the drafting. It's funny because we get CPAs who will just look at a trust and say, "Oh, well, this is a qualified disability trust," and we laugh and we say, "Really? How do you know that? Tell us."
Well, yeah, Steve, I'll have an article. I don't know if you're a Lissy subscriber or a Lineberg subscriber. We're going to have an article coming out on what I think about all this. I'm not sure that it's always a slam dunk that people think it is, but you have a very good point that qualified disability trusts give us an edge in a number of cases.
We don't want to bore you, but Mark and I actually fell in love talking about qualified disability trusts.
She called me up. All right, this is ridiculous.
Yeah.
Somebody wants to hear this.
Anyway, we think that it would be a really good time for people who haven't seen their planners in a while to have a chat with them. So I think it would be great if you could give a call to whoever you trust that's in your planning circle and discuss with them whether your plan needs to be updated, might not need to be, whether that's your estate planner, your financial advisor, whoever your first stop person is. If you have any further questions, please feel free to reach out to us. If you want to know who you should talk to in your state, please feel free to reach out to us. We'd be happy to connect you. If you don't want to reach out to us, you can go to www.naela, that's naela.org, to look for a practitioner in your state, or you can go to www.nelf.org, that's NELF, and they have the listing of CELAs, that's Certified Elder Law Attorneys, and those folks are likely to be qualified to be able to help with this very specialized field of practice. Any other last thoughts, Mark? This recording will be available hopefully in a few days on our website. That's specialneeds-law.com. And other than that, this is very exciting. Tax planners don't usually get such exciting news that they get to talk about and share with everybody. So Mark's having a lot of fun these days.
Well, we've got a record-breaking number of attendees coming to our NAILA webinar tomorrow.
Yep.
But you have to be a NAIL member to get into that. So if you're not, sorry.
Now I have to go take an aspirin because all of these IRS codes give me a little bit of a headache. I don't know if y'all are appreciating that, but man, oof, difficult. Anyway, have a great afternoon, everybody. Thank you for joining us. Bye now.